Okay, welcome back. I'm very excited about this session, which I'll let my colleague Alex Alvarez introduce momentarily. And before I pass off the microphone to Megan Reed here, this panel, or actually the next two in the keynote tonight, they're brought to us by the Zorian Institute, which, and Megan will say some more words about that, but I just wanted to personally say, how meaningful the Zorian is to me. I went through their program in 2015 and really changed the way I approach genocide studies. And they've become good friends and supporters of this conference. This is year number 3 we've collaborated together. So you're a greatly valued partner and look forward to the rest of the week together and spending some time with you this summer.
Thank you so much, Tim. My name is Megan Reed, and I'm the Deputy Executive Director of the Zorian Institute. The Zorian Institute is a nonprofit organization dedicated to raising awareness on genocide, human rights, and diaspora homeland relations through education and scholarship. So we're really excited to be here for Genocide Awareness Week. As Tim mentioned, this is our 3rd consecutive year. So we're very grateful to be here, and we're also very grateful for all of the organizers. I see many of you here today, especially Tim. Thank you for working with us to get our 3 sessions today underway. It's been always great working with you with this. And I do want to share a little bit about our work in general, but I also wanted to point out we have an exhibit out in the hallway. We just put it up this morning, but if you get a chance on your break to go check it out, please do. It's called Women in Genocide from Persecution to Empowerment. It's an exhibit that the Zorian Institute prepared in partnership with the Armenian Genocide Museum Institute in Yerevan. So please go check it out. It's going to be a traveling exhibit. So it is something that the Zorian Institute can offer other institutions as well. If you wanted to do any kind of commemorative event or something like that, you're welcome to use that material. And it's a comparative exhibit featuring the Armenian Genocide, the Holocaust, and the Rwandan Genocide, and it's focused on women experiences before, during, and after genocide. So feel free to check that out afterwards. But a little bit about the Institute. As Tim mentioned, he is a graduate of our Genocide and Human Rights University program. It is a 2-week intensive university program hosted at the University of Toronto every summer, the first 2 weeks of August. And it provides students with a foundational understanding of genocide and human rights. So we use select case studies, but also themes that are explored throughout the course of the 2 weeks. And we bring together many renowned scholars and faculty members, some are in this room as well, to explore those themes. And students come from all over the world. It really does become a network of genocide scholars. And you get to learn from one another. You get to learn from renowned faculty. So it really is a great experience. So if that's something you're interested in, you're welcome to come find me after today's session or visit our website, send me an email, genocidestudies.org, to learn more for that. We also host conferences, seminars, symposia throughout the year as well. We publish 2 academic peer-reviewed journals. One of them is right here, Genocide Studies International. I thought this one might be of interest to you for this week. The other one we publish is Diaspora, a journal of transnational studies. They're both published by the University of Toronto Press. So if you're interested in learning more about that journal, contributing to the journal, or have any questions about that, feel free to ask me. We also have 2 of our editors here today, Alex Alvarez and Henry Therio at the back as well. So if you have any questions, feel free to ask any of us. We also invest in original research and publication at the Institute. And we also have host a few podcasts as well. So those are available on all streaming platforms. So you're welcome to check those out as well. That's a little bit about the Institute. I'd now like to pass it over to Dr. Alex Alvarez to introduce today's speakers. Thank you.
Good afternoon, everyone.
All right. How's everyone doing? Good? Excellent. All right. All right. It is a distinct privilege and a pleasure for me to moderate and introduce our esteemed jurists who are going to be speaking with us today about some of their recent publications, some books. The way it's going to work is I'm going to introduce our first speaker, who is Dr. William Schabas, who's going to be zooming in, and he'll spend about 20 minutes or so speaking about his latest book. Then I'm going to introduce the person sitting here next to me, Judge Chile Eboe Osuji, who is going to speak about his most recent book for about 20 minutes or so, and then there should be plenty of time for some conversation and discussion, and hopefully we can have a really engaging session. So, to start us off, let me introduce Dr. William Schabas. He is a professor of international law at Middlesex University in London, emeritus professor at Leiden University and the University of Galway, distinguished visiting faculty at the Paris School of International Affairs, and an associate tenant at 9BR.
9BR Barristers.
9BR Barristers Chambers in London. Thank you. The third edition of his book, Genocide in International Law, which is the book on law and genocide, was just published in February 2025. Other recent publications include the International Legal Orders Color Line, Oxford University Press 2023, which we'll be learning more about today. The Customary International Law of Human Rights, Oxford University Press 2021, and the published version of the course he delivered at the Hague Academy of International Law in January 2021, entitled Relationships Between International Criminal Law and Other Branches of Public International Law. He has appeared as counsel before the International Court of Justice and the Grand Chamber of the European Court of Human Rights in cases involving the Genocide Convention. Professor Schabas is an officer of the Order of Canada and a member of the Royal Irish Academy. In 2014, he served as chairman of the UN Commission of Inquiry into the Gaza conflict. So please join with me in welcoming Dr. William Schabas.
Well, thank you very much, and a pleasure to be here. I'm sorry I can't be with you in person. I had hip replacement surgery about 3 weeks ago, and I'm not allowed to travel for the next several more weeks. And so I had to cancel my plans to come and be with you there in Arizona for this marvelous conference. You can see the cover of my new book up there on the screen, I think. Both the front and the back cover. That's a picture of Paul Robeson, the African-American singer, actor, athlete, activist, presenting a report to the United Nations in 1951 entitled "We Charge Genocide." So the link, although it's not developed in great detail in the book, but the link between genocide more generally and issues relating to racial discrimination, I think, should be obvious enough. This was a COVID project of mine. It was one of a number of ideas that I keep somewhere in a virtual file card system of possible research projects or books at some point. But it was really when I was locked down here in London, England, during the COVID pandemic, that I decided to sort of develop this project a little more in terms of studying the role that the campaign against racial discrimination had played throughout the history of international law. And that means going back perhaps 150 years. I was able to find a lot of the material, I think an enormous amount, online. So it was absolutely suitable to sitting in someone's kitchen in their pajamas and working away as if you were in a research library, exploring the various issues. And one of the things that I think, well, there are many scholars in the room here, and this may have happened to many of you or some of you, but it's a rare event, at least it has been in my experience. But I approached the research with a sense of the explorer going into an unknown area. I had some ideas, but I wanted to learn more about it, and I wasn't sure about the answer. And what emerged was something I think quite different than what I expected, because I was I did what developed, and I'll tell you a bit more about this, is a narrative.
Professor,
Yes.
this is Lisa. We're having a hard time seeing your presentation. Can you look at the top of your screen and where it says slideshow?
Yeah.
Do that and then put it on so that it's play from start. Yep. Perfect. Thank you. Sorry to interrupt.
Okay. So you have it now. Fine. This what emerged from it is a new narrative about the history of human rights more generally. I've been studying the history of human rights law pretty much all of my career, and I think I've accepted the conventional wisdom about it, particularly in the post-Second World War period, where the development of human rights law was largely the work of European and Europeanized intellectuals, led by people like Eleanor Roosevelt and René Cassin, and marked by such sort of waymarks as the Universal Declaration of Human Rights adopted in 1948, and then the two covenants on human rights adopted in 1966. And what emerged from my research is a different kind of a vision of how human rights developed, which was a consequence of the pushing, the struggling of people of the South, not just people living in the South, but some of the people in the North. I'm thinking of African Americans who were in the North, but they were allied with the people of the South and were and saw themselves also as, in some ways, the voice of the colonized in Africa, and promoting the issues that concern them the most, racial discrimination at the center of it, within the United Nations. So without questioning the classic view of the history of human rights, this is kind of an alternative narrative that maybe complements or completes the picture. Now, international law has been interested in issues of discrimination and racial discrimination for well over 100 years. We have to remember that international law, as we know it, was a creation of European states. It's a European law, essentially, and it was created initially in the 17th and 18th century by European states as a way to both address their own relationships with one another as they started to expand their interests outside of Europe, but also as a tool to govern or regulate what they were doing when they went further afield, including developing things like the slave trade and slavery and so on. The South slowly starts to make its incursions in international law towards the end of the 19th century. But the big event, and I don't have time here today to go through the whole history of it, but the big event is really the Paris Peace Conference, which begins in January of 1919, and which, as I'm sure all of you know, is the event that brings to an end, really, the First World War and creates a peace that is unstable and that, of course, collapses 20-odd years later with the Second World War. It's maybe the second most important lawmaking event of the 20th century, the most important one being, we'll get to that in a minute, the San Francisco Conference in 1945, when the United Nations is created. Well, the Paris Peace Conference, there were about 30 governments that were represented there, but like other big international conferences, and we see this today, as they attract others. They attracted people from states, or rather entities or territories that were not yet states, who attended, who sent their delegations there. They attracted non-governmental organizations, and they attracted here, and you can see these are clippings. You may recognize the newspapers they're from, the New York Times. Negroes ask for African colonies lost by Germany. These were African Americans, essentially, who showed up in Paris and campaigned there so that the German colonies, which were confiscated, so to speak, would then be given independence, like Liberia and Ethiopia, the two African independent states at the time. They were unsuccessful, of course. What happened was that these colonies were redistributed amongst the colonial powers, the United Kingdom and France mainly, but others got little pieces of them, including the United States of the former German colonies. And all of that fell under the League of Nations. There was a very interesting development at the Paris Peace Conference when Japan, which was one of the five great powers now, a non-European power, came with an amendment to the Covenant of the League of Nations. Japan wanted to put a clause on racial equality into the Covenant on the League of Nations. Japan was very effective in campaigning for this, got a great majority of the members of the Commission on the League of Nations at the Peace Conference, only to be blocked when Woodrow Wilson said, essentially, I veto this. If you want to know where the beginning of the American veto comes from, it first manifests itself here at the Paris Peace Conference when Woodrow Wilson, and then he's supported by the British, says, you can't do it. We don't want that clause in the Covenant of the League of Nations. Some of you maybe know a little bit about Woodrow Wilson. I have a little quote there that I put up on the screen, which appears in Griffith's film, The Birth of a Nation, a film that glorifies the Ku Klux Klan. And of course, there's Woodrow Wilson, who was a very profoundly racist Southerner. And you'll see the building there on the screen is the Palais Wilson, which today is the headquarters of the United Nations High Commissioner for Human Rights. My dear friend Chile, who's going to speak after me, knows that building well because he worked there for a while. And I have a quiet little campaign that I mention every time I can to get us to change the name of the Palais Wilson. This is a meeting of a body of the League of Nations called the Permanent Mandates Commission. This is where the supervision of the German colonies was undertaken, was carried out, and it was the first venue really for international petitions, because it was possible for people in those territories, these former German colonies, to make petitions to the League of Nations. And so it's the first place we see something that is today just an important part of our international human rights landscape, which is petitioning about violations. Many of the petitioners came from African territories in particular, and most of their complaints were about racial discrimination in the mandate territories. One of my favorite examples in there in the materials that I stumbled upon in my research was a report prepared by one of the members of the Mandates Commission, who was studying, she was very interested in education. I say she, a Swedish woman. She was the only woman on the Permanent Mandates Commission. She took a particular interest in education in Africa, which was obviously the education of the indigenous Africans was not at a level that we would expect, and certainly could not be compared with the educational system in the African colonies of European settlers who were there. And so how did she go about studying this question? She got a grant and went to the United States to study education in segregated Jim Crow schools in the United States, because she thought this would be helpful guidance as to how to educate Africans. Instead of going to Sweden and looking at the schools in Sweden and saying, this is how you educate Africans, she went to segregated schools in the United States. It gives you a flavor of what was going on in the League of Nations at the time. When the war breaks out, the Second World War, the League of Nations, of course, although it still exists on paper, is no longer operational. There's a famous meeting in 1941, just off the coast of Newfoundland, where Roosevelt and Churchill came, each one on their respective ships. You can see films of this on YouTube if you're interested, and issued what's known as the Atlantic Charter. And you can see here that they, echoing words of Roosevelt, they talk about how when Nazi tyranny is finally destroyed, this will provide an assurance that all the men in all the lands may live out their lives in freedom from fear and want. It was a very powerful message. I don't think Roosevelt or Churchill, either one of them really believed in the message. It was a cynical message, but many were captured by it. And you have here a quote from Nelson Mandela's memoir, A Long Walk to Freedom, who talks about how important and how well it was greeted. When Churchill got back to London from Newfoundland, he was questioned about this in the House of Commons, and he assured the members of the House of Commons that there was no question that there would be racial equality or that there would be an end to colonialism. And he made this famous quote, "Why be apologetic about Anglo-Saxon superiority? We are superior." The big event, the big law-making event, is the Charter of the United Nations adopted at the San Francisco Conference. There is an attempt to revive the vetoed Japanese proposal on racial equality. Obviously, it's not the Japanese doing it, it's the Chinese who do it. A Chinese diplomat named Wellington Koo, who goes on to be an international judge. And he attempts at the Dumbarton Oaks Conference to insert this clause into the Charter of the United Nations, but he's not successful. Finally, when the preamble of the Charter of the United Nations is drafted, this would have been the place for racial equality to be mentioned. It is the place where gender equality is mentioned. The equality of men and women gets a mention in the preamble to the Charter of the United Nations. Why did they leave out racial equality? Probably because the man who drafted it was Jan Smuts of South Africa. He didn't really believe in racial equality, even if he apparently believed in gender equality. One of the things that was important in the Charter for the powerful states, essentially Western European, the United States, the Soviet Union, was something called the Domestic Jurisdiction Clause, Article 2, Paragraph 7, which said that the United Nations was not to intrude on matters that were essentially of domestic jurisdiction. And many powerful, wealthy states assumed that this was a guarantee that the UN was never going to make trouble for them. And of course, the story of the United Nations and human rights ever since has been breaking down the doors of that clause. I'm going to move quickly. I'm going to move on to what I think is really an emblematic moment in this history of human rights in the United Nations. When the United Nations, it's created as a result of the San Francisco Conference. The Charter enters into force in October of 1945. And then in early January of 1946, the institutions are created: the General Assembly, the Economic and Social Council, the Security Council, the Secretary General is elected, and the International Court of Justice is created. There's a subordinate body that's supposed to be responsible for human rights, and this is called the Commission on Human Rights, but it doesn't meet until January of 1947. When it meets in January 1947, the first item on its agenda is drafting the Universal Declaration of Human Rights. And it largely devotes its activity to doing that over the next year and a half. The declaration is adopted in December of 1948. And in the history, the narrative of human rights in the UN that I was taught, and that I then spent 30 years teaching to my students, this was really where human rights were at in the United Nations. But when I read the report of the Commission on Human Rights, not the report, but this was the opening statement delivered by a representative of the Secretary General in January of 1947, the Secretary General said, we've already been doing human rights. We had our first session of the General Assembly in 1946, And we adopted 3 resolutions dealing with human rights. So I mentioned these resolutions here on the screen. The first one is a resolution proposed by South Africa about the discrimination against, a resolution proposed by India about the discrimination experienced by members of the Indian diaspora in South Africa. South Africa howled in outrage, said that this was impossible to raise this at the United Nations because these were matters of domestic jurisdiction. And by 1 vote, India carried the day and blew a big hole in that clause, that the domestic jurisdiction clause of the charter. The second resolution of importance was proposed by Egypt, and it dealt with persecution and discrimination, racism. And it was adopted unanimously in November of 1946, although there were attempts to block it getting onto the agenda of the General Assembly. But once it was on there, it was unstoppable. And it became the bellwether resolution on racial discrimination until the 1960s, when new instruments were adopted. And then the third resolution that the Secretary General said was a resolution on human rights was the resolution on genocide. And this resolution, and I'll say a little bit more about it later today when I talk about the Genocide Convention, this was adopted in December of 1946. And it was proposed by 3 states, by India, by Cuba, and by Panama. So here we have 3 resolutions. It's not me saying this. This is the Secretary General of the United Nations making this observation in January of 1947, that we have 3 resolutions at the very first session of the General Assembly that deal with human rights. And those 3 resolutions are proposed by India, Egypt, Panama, and Cuba. You see the common denominator there? They're all countries of the South. They're countries of the South that had never before been players in international law until they were there in the United Nations General Assembly in 1946. There's other stuff going on there at the General Assembly as well. I'm going to maybe come back to this in a few minutes, but there were attempts to petition the United Nations. And I showed you the cover of my book, which has Paul Robeson. There he is again with W.E.B. Du Bois, the famous African-American intellectual scholar. And they started trying to bang down the doors of the United Nations with petitions to the United Nations in 1946 and 1947. And the one they were most effective with was this petition called We Charge Genocide, which was presented in 1951 to the UN General Assembly, which was controversial. It was a brilliant piece of work, in my opinion. They dealt with lynching in particular in the United States, and it was opposed by none other, someone we're going to come back to, and a name many of you will be familiar with, Raphael Lemkin, who by then in the 1950s had become somewhat of a cold warrior, and he had no sympathy at all with the African Americans, and so he saw this as a distraction. It was also not welcomed very much by Eleanor Roosevelt, another iconic figure in the human rights movement, although someone who was more, I think she was more embarrassed by it than anything. UNESCO took on a particularly important role for a few years, and mainly in the early 1950s, where it tackled the issues of scientific racism, issues of racial superiority or inferiority that had been promoted within the scientific community, mainly by the Nazis, of course, in the 1930s. But as I think most of you know, those ideas, those noxious ideas, eugenics, racial superiority, and so on, were not absent in the academy in the United States, in the United Kingdom, and elsewhere. And the chair of the panel in UNESCO that adopted this declaration was Franklin Frazier, an African-American sociologist. Apartheid became a central theme in the work of the United Nations, really for more than 40 years. And the first report that was ever done in the United Nations on human rights was a report of a commission that was set up in 1952 by the United Nations General Assembly. Again, most of the histories of human rights in the UN talk about this happening in the 1970s, that all of this starts in the 1970s. Samuel Moyn wrote a book about this. It was a bestseller some years ago, but actually there's a lot of this stuff that's just hiding in plain sight, and you have to go and dig it out, and there it was, this report. I attended part of the session earlier today, and I was struck by, and I have a line in there you can see where I talk about the support for the resolution of the General Assembly in 1952 to deal with apartheid. And it's split on global lines, with the countries of the South favoring this study, and the countries of the North opposed to it and saying that this wasn't an appropriate job for the United Nations. And I mentioned there in parentheses that Israel in 1952 voted with the South. Israel during the 1950s and into the 1960s was very much aligned with the anti-colonial states of the global South, although that would change by the time we get to the 1960s. And then we have a period in the 1960s where there's great legal development in the field of human rights. One of the features of the human rights treaty regime is that the first two human rights treaties are basically derived from the Universal Declaration of Human Rights, and it takes a long time to finalize their text. The Universal Declaration is adopted in 1948, and when it's adopted, the thinking is that they'll probably get the treaty adopted, called the Covenant, the next year. But it's going to actually take more like 17 years before they can finalize it. And in between, there's a leapfrogging of another resolution that comes along dealing with racial discrimination. So there's a series of very important developments in the 1960s. They are a result of the arrival of new African states in the United Nations, 16 of them in 1960, and then more in 61 and 62. And they flex their muscles, and one of the things that they do when they adopt this really what's the most important resolution of the General Assembly on the subject, General Assembly 1514, which is adopted in 1960, is they include a reference to the Universal Declaration of Human Rights in the resolution, but they put it in what we call an operative paragraph. 99% of the references to the Universal Declaration of Human Rights are placed in the preambles of General Assembly resolutions. And here, I'm going to stop now. I know I'm probably
okay. Thank you.
I'm going to finish with this.
Thank you for that presentation, Dr. Schabas. Let me turn now to our next distinguished panelist. It gives me great pleasure to introduce Judge Chile Eboe Osuji, who was the fourth president of the International Criminal Court and served as a trial and appellate judge of the ICC from 2012 to 2021. He is the distinguished international jurist at the Lincoln Alexander School of Law at the Toronto Metropolitan University and was recently appointed as a judge for the Caribbean Court of Justice. Prior to joining the ICC, Dr. Eboe Osuji served as the legal advisor to the United Nations High Commissioner for Human Rights in Geneva. Earlier in his career, he also worked at the International Criminal Tribunal for Rwanda and at the Special Court for Sierra Leone as a senior prosecution counsel. Before joining the International Public Service, he practiced law as a barrister in Canada and Nigeria. Following the end of his tenure at the ICC, he served as a visiting professor for several prestigious universities and taught as adjunct lecturer at the Faculty of Law of the University of Ottawa. He is a member of the high-level legal panel on media freedom and a senior peace fellow of the Public International Law and Policy Group. He has an extensive record of legal scholarship, including the books End of Immunity, Holding World Leaders Accountable for Aggression, Genocide, War Crimes, and Crimes Against Humanity, which we'll be learning about today, International Law and Sexual Violence and Armed Conflicts, and Protecting Humanity. So without further ado, take it away.
Thank you. very much. Okay. For that kind of introduction, ladies and gentlemen, it's a great honor and privilege for me to be here and also to be sharing a stage with my very good friend, Professor Schabas. We're very, very good friends. We agree on 95% of the time in international law. We reserve the 5% for when friends have other views on things. Now, we will also, in the book, The End of Immunity, is another book that has strong links to the end of the First World War, and I will tell you about that. But on your screen there is a quote from Omar de Vattal. Omar de Vattal was one of the celebrities of international law in the 18th century. They said there is at least one benefit. I mean, I put it up there because a lot of what's going on now that make us worry is international order going to hold? Are people respecting international law? A question my very good friend Rex is in fact there is always asking was a question they too were facing during the time of Omar al-Battar. He tells us there is at least one benefit to be expected from the open assertion and publication of sound maxims, which is that even those who relish them the least are thereby laid under the necessity of keeping within some bounds, lest they should forfeit their characters altogether. But to flatter ourselves with the vain expectation that men, and especially men in power, will be inclined strictly to conform to the laws of nature, that's how international law was referred to in those days, would be a gross mistake. Yet to renounce all hope of making impression on some of them would be to give up mankind for lost, unquote. That's what we do, folks. Even though things may seem so dystopian, I would say we have to keep repeating the norms of international law that have been accepted since definitely 1945, even earlier to 1919, as Professor Schabas tells us correctly. Now, the book, End of Immunity, I begin as Professor Schabas did with a cover image there. When you look at it, what do you see in the picture? You see perhaps images of Gaza, images of Homs in Syria, and other places that have been devastation, images of Dresden during the Second World War. Hiroshima I wouldn't mention because the whole place was flattened, and Nagasaki, but that's not that. That is a picture of Louvain or Louvain in Belgium during the First World War, one of the signal stories of the atrocity of that war. The Louvain, town of Louvain, where you had the university, was bombed, and the library of the university was flattened and destroyed, and that was decried. It's one of the worst atrocities of that war, attacking universities and the libraries. So the End of Immunity was the title of the book about. Does it sound too ambitious? Does it announce a future norm? No, it does not announce a future norm. It announces, or rather stresses, the norm of international law as it now is. It's not something we expect, End of Immunity in future. The title of that, or the inspiration, is, if you looked at the Rome Statute of the International Criminal Court, Article 27 of that instrument says that no one enjoys immunity before that court, even heads of state or heads of government. Article 27 of the Rome Statute, adopted in 1998. You move backwards, you see Article 7.2 of the Statute of the International Criminal Tribunal for the former Yugoslavia, says the same thing. No one enjoys immunity, even heads of state and heads of governmental ministers. Article 6(2) of the Statute of the International Criminal Tribunal for Rwanda says exactly the same thing as Article 7(2) of the ICT, what that's Yugoslavia Tribunal says. Article 6(2) of the Statute of the Special Court for Sierra Leone, another international tribunal, again, the same thing. Now, you go back to 1945, Article 7 of the Charter of the Nuremberg Tribunal says the same thing. Article 6 of the Charter of the International Military Tribunal for the Far East said, in a different language, the same message. And Article 2 of the document called the Control Council Law number 10, 1945, say the same thing. Control Council Law number 10 was an instrument that the Allies enacted so that they could, in their various areas of occupation in Europe, specifically in Germany, that they could do coordinated prosecution without bumping into one another, so that if England is, UK is prosecuting somebody in its zone of occupation, and the US is prosecuting somebody else in its own zone of occupation, and the two trials or two tribunals with the national jurisdictions in those zones of occupation needed, say, a witness, they wouldn't be fighting it. There'd be ways of coordinating it. So that's article, that is Control Council Law number 10. The point is that all these instruments, say, from 1945 up to 1993, ICTY statute, 1994, ICTRS Rwanda statute, to the Rome statute, all say no one enjoys immunity. They didn't just leave it at that. They said, including heads of state and heads of government, named as such. Now that story, you say, okay, well, of the book is to say that norm was not an accidental development. It had an origin that was purposeful in its time. It was meant to be, it was not a footnote in history. And that origin goes back to what? End of First World War, the Versailles Peace Conference that Professor Schabas talked about. The Versailles Peace Conference did quite a bit of things, and Professor Schabas has indicated one thing that it did, try to create the League of Nations. Another thing that it did was that idea that from now on, from the end of the First World War, leaders of states who engage in conduct that are deemed as international crime will be punished before an international tribunal, and they would not enjoy immunity. That was a deliberate exercise in international law reform, deliberate in the sense that, yes, Woodrow Wilson, as Bill Schabas pointed out, had his difficulties with racism, but he was the first American president who, while in office, traveled to Europe. The very first time American president, serving American president, sailed to Europe. Why did he go to Europe at the end of the First World War? Some of you may know he went there because he wanted to create the League of Nations and other things. Okay? Now, there were some other world leaders. The Prime Minister of the UK, David Lloyd George, and the Premier of France, Georges Clemenceau, in whose country the conference was holding, the Paris Peace Conference was holding, these two leaders had something else troubling them. And the thing that was troubling them more than the creation of the League of Nations was the trial of the Kaiser of Germany. They were determined that the Kaiser must be tried because the populations demanded it. So did populations around the world, including in the United States, said, look, the Kaiser must be tried. And the story of the end of immunity is to tell the story of the debate that happened during that exercise. The book is written in a way, it's on to the story. The book is written in a way that deliberately I wrote it to ensure that not only lawyers can follow the story, but anybody who has a degree in any field can pick up the book and follow it. And my friend Greg Takeshit here called me up and then, he sent me an email. I woke up and in the morning I saw an email from him. Chile, I picked the book, I arrived at 11:30 p.m. and I made the mistake of opening it. So I said, oops. It turned out that was one of the best compliments someone had given to me. Another one was from my father-in-law, who's a doctor, a cardiologist and not a lawyer, not a political science, said he very much enjoyed reading the book. So the point is that it was written for anybody to pick up and follow the story. And that story was how Clemenceau and David Lloyd George told Wilson, because when the debate, the negotiation of the Treaty of Versailles was ongoing, and these two leaders, France suffered great devastation during the First World War. Some of you know the French people value their agriculture, their food, and all that. The French farm fields were torn up by Germany. About 4 million French soldiers died in that. So that they were saying, look, yes, Woodrow Wilson, you can, yeah, League of Nations, that's important too. But first, we have to try the Kaiser. And the UK was also behind that project. Now, during the negotiations of the text that ended up being translating into what we now see as Article 227 of the Versailles Peace Treaty. Now, Article 227 Versailles Peace Treaty 1999, I would say, was the beginning of the idea of administration of international criminal justice. It didn't work out, but the taboo was, the genie was let out of the bottle in that exercise. Article 227 says that we are publicly arraigning the Kaiser of Germany for trial before an international tribunal to be composed of judges from 5 countries, including the United States and all that. Now, there was a debate of that. It wasn't a smooth selling exercise. There were some technical lawyers who were representing the United States. There was a committee of 10 states called the Committee on Responsibilities who negotiated that text, or the report that produced that text. Amongst the 10 of them, the delegation of the United States stood against the idea of trying the Kaiser. They said there's something called sovereign immunity. This is new idea to try and sovereign of a nation before an international tribunal. There was no precedent for it, argued Robert Lansing, who was the Secretary of State of the United States at the time. Now, the other delegations, led by the British Solicitor General, Sir Ernest Pollock, King's Counsel at the time, basically was diametrically opposed to Lansing's position. So Lansing was arguing, well, we don't want to try the Kaiser. And the British Solicitor General Pollock said, if we're not going to try the Kaiser, we're not going to have a treaty. We're not going to have this instrument you're trying to create. It's not going to work because the British Empire stands firmly, resolutely in favor of trying the Kaiser. We want nothing less than that. So the debate now, an interesting debate. Remember here I mentioned that all these norms say no one enjoys immunity, including heads of state. Now it came to a head when Lansing said, well, there is in the report we are looking at, says no one enjoys immunity, however high their position, regardless of rank, including heads of state. I said, well, we've already said however high, regardless of rank. Why do we also have to say including heads of state? Doesn't however high, regardless of rank, cover heads of state already? So let's delete including heads of state because it is a superfluous phrase in the formulation. Lansing said, no, we're not going to delete including heads of state because we want to be very clear that we want heads of state included in those who will be tried. We don't want to be left in a scenario where somebody is construing or interpreting the meaning of authority, and then you end up saying, well, in national authorities, heads of state do not come in as part of that. So we don't want to be left with that kind of bag. So we want to spell out including heads of state because that is what we want. And the French delegation also supported that. Lansing goes, well, you're telling me that by this, we are exposing our heads of state, including the King of England, including the President of the United States, for prosecution because they did not prevent violations that soldiers committed in the field. I can accept that. But Locke stood up again and said, look, we're not impressed by that argument. We are saying, we from the UK, that if the King of England did what the Kaiser did, the British people would say, try him. And we, of course, he speculated on this one. Well, we very much think that American people would say the same thing if an American president did what the Kaiser did. That was followed. Now, the point there is not to assess the accuracy of that kind of speculation. The point is to stress the determination of UK and France that heads of state and heads of government must be tried in future. Let me quickly refer to the point. Clemenceau, in a debate amongst the four leaders of that conference, Paris conference, the four leaders being Woodrow Wilson, David Lloyd George, George Clemenceau himself, and the Prime Minister of Italy, Vittorio Orlando at the time. They were the leaders, were called the Council of Four. In a debate amongst them, Vittorio Orlando was a lawyer, professor. So, well, I really am impressed by, yes, I do want the Kaiser to be tried, but I do worry about the absence of a precedent for this sort of trial for head of state, for nation. That worries me. And the minute he finished, Clemenceau jumped down his throat, saying, what do you mean by precedent? What does precedent mean? Does precedent not mean something that was done by somebody the first time? Who are we expecting to do this for us? Yes, it hadn't been done before, but we are going to do it now. That is the point of this exercise. And he continued then, saying that people everywhere would be satisfied if this could be done. They will feel that justice in future will be done in the case of Kaisers and kings as much as in the case of common men, unquote. So that was it determined the insistence that the Kaiser would be tried. That was a determined insistence that heads of state and heads of government who commit atrocities in future would face justice. How many minutes do I have?
2, 3.
2, 3 minutes. Why don't I just leave it at that? I would take a question. So there's a lot that can be said about the book, but the story, it's all there. I think I'll leave it there and take any questions. Okay. Come on. Thank you very much.
All right. All right. We have about 15 minutes for some questions and answers. So let's start.
Law 200 years ago, well, 20 years ago, in Malaysia, which is a different part of the world, we only spoke in terms of criticizing international law. We spoke about the toothless tiger syndrome, which means international law roars, but it has no teeth. Today, things have changed. We're talking about universal jurisdiction. Countries such as France, South Africa recently, are going after genocidaires from different parts of the world. And it happened in the case of a Rwandan gynecologist in France, and ISIS, some of the members of ISIS are being tried in Germany by the Yazidi community, etc. I want to know, what is the next step? Because all of these laws, obviously, there's a subtext in our conversation today. I want to know, what are the protections we may have against these leaders whom you've discussed today? Because, as I said, international law has changed. We can't be cynical about it. Over 20 years, it's changed. But what's the next step to make it even more applicable and usable in practical circumstances like what we're faced in right now?
Glenn, you want to go first?
You're muted.
Chile, go ahead.
Well, while you do that, while you get Professor Schabas on, I can take a stab. That is a brilliant question. So one would expect from this audience, of course. This afternoon, later I'll be giving a keynote, and the keynote to the right to peace. And where we go, that's one area. I don't want to talk too much about that, but what I can say that I do understand that concern you've expressed, and it is on the mind of almost everyone. Almost behind you is again my good friend I wanted to, the Circassian, who also worries about this. I like to sound optimistic, not because I merely want to, I want optimism to run on fumes. I sound optimistic because I find that, and I tell that story in this book, chapter 15, that I would say most of the profound developments of international law have resulted from cataclysmic periods, events such as we're now facing. And I use the optimistic imagery of international law and lawlessness having a relationship of the boa constrictor and its prey, international law being the boa constrictor. Of course, the prey can be a crocodile. As the boa constrictor is going after, it could be something else. But the point is, the imagery of the boa constrictor is that, they're constricting with every movement, so the animal tries to, tighten the grip. And that is how I see it. From 1648, the Peace of Westphalia, by all through to today, be it the 1899, 1907, the Hague treaties, or 1868, the St. Petersburg Declaration and all that. So every time you look pronouncements on international law, something that expands it, make it stronger, come out of armed conflict or questions related to war. And I do think that what we're going through will also give us perspectives on how to strengthen international law after this is over. And this too, as the famous Chinese saying goes, shall pass. I'm a great believer in the Nietzsche doctrine that whatever doesn't kill you will make you stronger. I'm serious. And I do this when we experience ill health, especially the ones that don't kill us, at the end of it, we appreciate life more, right? Because when we are gripped by that ill health, it looks like the end of the world. We're not gonna see tomorrow. But then after we emerge from it, there's a certain freshness that makes it all right. Look, I survived this thing. How do I make the most of life? I think the end of this era will tell the world to not take as much for granted what they're taking for granted all along. Taking for granted that, well, nations no longer invade one another, as happened in Ukraine, and we're hearing stories of we take this place and the other place today. There was a time we took for granted. People don't do that sort of thing anymore. So I do strongly believe that we will begin to appreciate the international law more. We will begin to appreciate the International Criminal Court better after this whole spate of this stuff here. That's what I can say. This afternoon, I was talking about my Right to Peace project, something else we can do to strengthen the international law. Thank you.
Dr. Schabas, would you like to respond as well?
Yes, let me add a contribution to this point, to this question. International law is a law that is very largely, if not entirely, created by states. And so it has all of the weaknesses and imperfections that one would expect, because states behave in a lawless manner often, and they want to ensure their ability to do so without running afoul of the law. So there's a lot to be done still in terms of strengthening international law, but that's not really the problem, and I don't think it's the issue that the person who asked the question was trying to get at. The other problem with international law is an enforcement problem, because the enforcement of international law is not something that the law itself can do. It depends on political institutions. It depends on governments, and it depends on international political institutions for its enforcement. And that's where we have a huge problem. The good news is that there seems to be a turn towards international law by a lot of states. And this is a very recent phenomenon. I'm talking 5, 6, 7 years. States are increasingly resorting to bodies like the International Court of Justice to find solutions, to find answers to problems that have hitherto been left to the political sphere. And I think that's a very positive development. It's a very constructive feature of international law at the current time. And hopefully it's going to continue. We have a strong International Court of Justice that has been showing itself to be disciplined but dynamic at the same time, and reaching strong, convincing opinions with strong majorities. So these are victories for law. But of course, we just have to turn on the news for 3 minutes to see that we live in a lawless world.
I have a question based on a complete misreading of the title of your book. And that misreading can only be explained by psychologizing myself, either as wishful thinking or an anxious mind. The way I read it, the end of immunity, I read it as the new era of impunity. Because I feel that's where we are, that we're entering a new era of impunity where you can pretty much do whatever you want and get away with it internationally and nationally. So I was thinking you addressing this in your book, and then I suddenly realized, oh, it's just saying the opposite. So anyway, I just want to throw this out because I felt like that's where we are, not the end of immunity, but moving into a new era where it's just impunity you can do, and no one knows how to respond to it. And that kind of adds a little bit to where William Schabas just ended it, like where are we with this, that there's no enforcement mechanism.
Tim?
Maybe you could tell that to Rodrigo Duterte, who is sitting in a cell in The Hague right now, former president of the Philippines.
As an answer to you, it's because the people don't control the money supply and cannot defund the government when it misbehaves. We need to go back on the gold standard. But I digress. I have a concern that we are conflating actions and events that don't rise up to the level of genocide with genocide. And in so doing, watering down the charge of genocide. So when a real one does happen, it is not taken seriously. For example, I don't think racial discrimination is genocide. I may be wrong, but genocide, at least as defined by Raphael Lemkin, does not seem to allow the racial discrimination to rise up to that level, according to that definition. That's my concern. I mean, I don't want to, if we cry wolf or say the sky is falling, then nobody's going to believe us when the sky actually falls. That's my concern.
That's an important point to make, but I don't think, I doubt very much anybody would say racial discrimination is genocide. The problem is there's a standard definition of genocide that has the 5 acts of genocide, 5. Oftentimes people will think only about killing, but killing is not the only act of genocide. There's killing, there's infliction of serious and mental bodily harm. There is, taking children of one group to another group, and 5 of them.
Cultural destruction, yeah.
And not necessarily cultural destruction, but, the point is when some acts or any of those 5 acts are done with what we call intent to destroy a group in whole or in part as a group, then we are looking at genocide. And it doesn't require killing every member of the group or doing those 5 things to every member of the group. It is enough. The case law, the International Criminal Tribunal for Rwanda, I used to be a prosecutor in that tribunal. A case called Akiyesu was the first judgment of the International Court on Genocide. The judges explained, as did Raphael Lemkin in his thesis, that you don't need to kill everybody in the group. You don't even need to kill a whole lot of people. If you killed one person, explain the ICTR trial chamber, killed one member of that group because you don't really care about that person. You just, because they're a member of the group you intend to destroy. That can raise question of genocide. So killing a limited number of people can trigger questions about genocide because the victim as such is not the individual victim. The victim as such is the group that that individual happens to represent, to be a member of, in the mind or the assailant. This is a symbol of that group. So we'll start there. After all, in any event, killing, even if we pitched the analysis at the level of killing, people are killed one at a time in most instances before you get to, killing 6 million people. So that is one problem with that. Oftentimes I hear the debate about how many people do you need to kill before you have a genocide? And people will say, well, genocide that happened to a certain group did not amount to the same number as the genocide other people suffered. Therefore, but I do believe that that kind of argument actually does the opposite of your concern, because it pitches the minimum level for genocide at the number that we are seeing. This is the big number, so that's what it should be. Yeah. Whereas lowering it will accentuate the magnitude of the larger group that suffered the crime, rather than do the opposite. So that's how I would approach that concern.
I'm certainly not saying there has to be a minimum number, but it's not a sharp line.
It's not, no.
Would you say that colonialism is genocide?
Nobody's saying that.
Just generic oppression
but
is genocide?
When people are killed in the context of making colonialism work, yes, you can have a genocide. If people are killed in the context of racism, yes, one can have questions of genocide asked in those circumstances, but not in every case.
Let me just quickly add too, that the next panel is Dr. Schabas, who's going to be talking about genocide and law. So maybe some of these issues might well be addressed in that. I just want to allow room for one more quick question before we need to break.
So I go in the same direction as Saba, who asked the first question about, toothless tiger and the problem of enforcement. But it seems to me that as international organizations and the ICC are trying to develop mechanisms of enforcement, and with some success, public opinion, especially in Western nations, is plummeting. International organizations are enjoying less support now than they did before. So I think the problem is not only the problem of enforcement, it is also that international organizations are kind of in a conundrum that as they try to develop teeth, Western public opinion is pulling those teeth at the same time. And that's an enormous problem, that they just do not enjoy that kind of credibility, especially in the West as they did in the past.
Bill, do you want to come? I'd like to answer that question, but I'd like Bill to go first.
Well, I just answer it with a question. How do you measure that? I'm not. I'd be anxious to see a little demonstration of that. Why you think that that international organizations are less respected or effective than they were, and that it's because of changing attitudes in the West? I don't know that there's anything to that. There are some leaders in the West and some voices that hate international organizations. We know that, but the United States is not going to withdraw from the International Criminal Court. It can't. It's not in. But I don't see any of the 125 current members withdrawing from it.
If I may add to that, I mean, that's a question that also gets does come up. But when you ask the question, what really is going on? For instance, as we speak, there's a piece I'm working on now had to deal with the stance of the International Criminal Court on this question of immunity. And somebody writes a commentary where they do not engage on the conduct that International Criminal Court is inquiring into, whether or not that conduct was legitimate, whether or not that conduct was criminal or permissible. No, there's absolute silence on the conduct of the individual, but focusing more on, well, the legitimacy of the ICC. There are some state practices that begin to question that. I say, okay, let's even stop it there and analyze that complaint. When you say, I'm not talking about you now, just another complaint. When you are talking about state practices turning against the ICC's assertion of immunity, I'm going, okay, let's inquire to that. Are you saying calling that state practice, by the way, for non-international law, is what states do consistently, believing that they are law regarding and doing it that way, either because they're obeying international law, or they want to create future international law. So let's look at that state practice this person is pointing vaguely at. Are we talking about the state practice of, say, that was communicated by President Biden. When President Biden said, yes, prosecute Putin before the ICC, but no, you cannot prosecute Netanyahu before the ICC. Is that state practice? We're talking about state practice of Lula of Brazil. So yes, prosecute the Netanyahu before the ICC, but don't prosecute Putin for the ICC. And we're talking about state practice of the former premier of France. Yes, prosecute Putin before the ICC, but Netanyahu is our ally. Don't prosecute him before the ICC. Is that state practice? That is where that was. So it ties into what Bill's saying. Sometimes these claims are made, but we don't find the real basis for them about turning away. We know, take for instance, in the average state where you have a leader, of course, the leader will project what he or she stands for. Without question, there will be some citizens of that country who will find their voice in their leader. But that does not account for the voices of all the citizens of that country. So that is where Professor Schabas' question comes in. It's interesting to see what studies are looking at that account for that. Thank you.
Well, we're at time. These were two wonderful and refreshingly optimistic presentations. I hope you enjoyed them. Please join me in thanking once again Judge Eboe Osuji and Dr. Schabas for their presentations. We will be starting up in 15 minutes.
Yeah, 3:50 or 10-ish.
10 minutes. Okay, thank you.
We'll continue the conversation with Dr. Schabas in 10 minutes.